and if members can do the needful, their electronic devices. Members' apologies from Sydney Anderson, and I'm sure other members will attend shortly. The draft minutes of the 25th and 7th of March are available. If members are content that they're accurate, then I will sign them accordingly. Matters arising, there was a response from the Lord Chief Justice in respect of the judicial appointments process and for a High Court judge competition. On the 6th of March, the committee agreed to write again to the Lord Chief Justice, clarifying the jurisdiction of the committee in respect of judicial appointment policy and processes, and to reissue its invite to the Lord Chief Justice and Lord Justice Coughlin to attend a meeting. The Office of the Lord Chief Justice has responded, indicating that the Lord Chief Justice remains of the view that it's not within the remit of the committee to inquire into a pre-devolution judicial appointment, and for that reason Lord Justice Coughlin will not be accepting the committee's invite to attend a meeting. The Lord Chief Justice, however, is willing to meet with the committee when convenient to discuss the judicial appointments process in general, and believes that he will be able to assist, but has asked that the committee respect his position regarding limitations in relation to the specific judicial appointment. So I think we've made some progress. We'll bring the Lord Chief Justice here. If he doesn't want to ask questions, I'll certainly be putting to him nevertheless, and if he wants to say no comment, then he can do so. But we'll go ahead and try and set that meeting up at the appropriate opportunity. And two's further information from the Department following the oral evidence session on human trafficking bill. During the evidence session, the Department, in respect of the bill on the 6th of March, officials agreed to provide further information around how many people had been helped out of prostitution by the Department of Justice. A response has been provided outlining that neither the Department or any criminal justice or health agencies who provide services and support for individuals who may wish to exit prostitution record any data, as the services are provided in a discreet, confidential and non-judgmental manner. A copy of the Strategy for Reducing Offending Among Women 2013-16 sets out in Chapter 4 actions that are taken forward in this area. Also, there's correspondence from the Department giving an update on the Desert Crate College. It's pages 3 to 7 of the table pack. It was emailed to members yesterday. The Department has formally indicated preferred bidders been unable to demonstrate to the team that they can take forward an affordable and compliant bid in order to enable a guaranteed maximum works costs to be agreed for the construction of the college. The Programme Board has therefore accepted a recommendation that the team should discontinue the current stage in the procurement process with the preferred bidder. So members have the information. The Minister will be with us shortly, and I know I'd already asked him yesterday if he would be content to take some questions around this, and he had indicated to me that he was, so members can refer to that as well at a later point. Item 4 is the oral evidence session with the Minister in respect of the Honour Runs Administration scheme and letters. So if the Minister wants to come in. Again, at our meeting on the 6th of March, we discussed the On the Runs administrative scheme letters and the letters that have been issued through it. We agreed to request the attendance of the Minister as well as other individuals. The committee subsequently has had evidence from the Permanent Secretary of the Department, and that was on Tuesday the 25th of March. And the Minister is here with us today. So, Minister, you're very welcome, and thank you for facilitating the committee's request. And as usual, this will be recorded and published in due course. So I'm going to hand over to you, Minister, at this point to make opening remarks, and then we'll get into some questions.
Okay, thank you, Chair, for the invitation to discuss the On the Runs administrative scheme. I welcome the opportunity to once again put my position on the record, although I fear I'm now at the risk of repeating much of what I've already said both in the Assembly Chamber and in the media. Before discussing the scheme itself, I do want to make it clear that I have full trust and confidence in Nick Perry as Permanent Secretary of my department. I've consistently and publicly supported the way he has dealt with this issue. I completely reject the suggestion made during last week's committee meeting that my department is dysfunctional or that Mr Perry's actions have caused me embarrassment. I have a very good working relationship with Mr Perry, and I believe that we carry out our respective roles as political and administrative heads of the department appropriately and effectively. I am confident that Mr Perry has acted entirely properly throughout. Following the Downey judgment and the receipt of an FOI request, Mr Perry ordered on my behalf a review of the files held or recorded in my department's central records management system. However, given his previous knowledge of the scheme, Mr Perry did not himself become involved in the review, tasking it instead to the highest-ranking departmental official who had not previously been with the NIO. This review identified no files relating to the administrative scheme. Turning to the on-the-runs administrative scheme itself, I will again make clear that prior to the Downey judgment, I was unaware that such a scheme was in operation. I first became aware of it when I received a telephone call from the NIO on Friday the 21st of February to brief me about the Downey judgment before it became public on Tuesday the 25th of February. Knowing that my department had no role in the scheme, I arranged to meet the Secretary of State on the 27th of February. When, on the 26th of February, she made her comments about it being a devolved matter, I insisted on meeting her that evening. Without going into details of our discussions, I can say that we had a robust exchange, and the Secretary of State apologised and subsequently apologised publicly for wrongly implying that my department was responsible for the scheme. And for the record, I did ask her if there were any other issues like this lurking in the woodwork, as Mr McGlone put it last Tuesday. She gave me an assurance that there were not. I've also sought my own legal advice on the scheme. The committee made much of this during Mr Perry's appearance. On other occasions, as Mr Perry explained, I've asked for legal advice without a formal request going through the Permanent Secretary. It's the convenience of having an office located in the same building as the department's legal advisors. On this occasion, I made a deliberate decision to seek my own legal advice without any formal request going through Mr Perry. I later informed Mr Perry of the fact that I had sought legal advice. I consider it entirely appropriate that we seek independent legal advice from separate legal advisors, given the different nature of our roles, mine as Minister and his as head of the department, but with the previous role in the NIO. As I have repeatedly said, my department has had no involvement with the scheme and so does not have information on the requests made, nor the contents of letters and names of those to whom letters issued. That information is held by the NIO, and the Secretary of State made a statement in the House of Commons last week on the number of cases considered by the NIO. Clearly, the PSNI and PPS have been involved in operating the scheme even since the devolution of policing and justice, but you will appreciate that the PSNI has operational independence and the PPS is not in any way accountable to me. With regard to the PSNI, it was already providing information to the Policing Board. In relation to the Northern Ireland Prison Service, which I am now responsible for, I said in the Assembly chamber that I was making inquiries of the Prison Service about the reference to it in the Downey judgment. However, the reference relates to the period prior to devolution, when the Prison Service was the responsibility of the NIO. In line with the Ministerial Code and the long-standing conventions preventing me from asking officials about the papers or information available to a previous minister, I've asked the NIO for relevant information. If the NIO does not agree to pass papers to the DOJ, I will raise the reference to the Prison Service with Lady Justice Hallett. The committee will be aware that Lady Justice Hallett has been appointed to carry out a review and to report to the Secretary of State. The terms of reference were clarified by the NIO earlier this month, and that information is in the public domain. Lady Justice Hallett also published a statement outlining her approach on the 27th of March. Her team has already started work, and I met briefly and informally with her on the 24th of March 2014 and expect to meet with her again. I await her findings with interest, along with those of the Police Ombudsman and, in due course, the Policing Board, the Northern Ireland Select Committee, and, of course, this committee. I also had an informal discussion with the Select Committee on the 28th of February. The Secretary of State made the welcome announcement on the 7th of March that the scheme had ended, but I'm conscious that there are many issues to be resolved, and I'm as keen as anyone to ensure that that is the case. In doing so, my main concern is to look after the interests of victims and their right to seek truth and justice. Since becoming Minister, I've been working to reform our justice system and build confidence in it. We've been making good progress, but controversies such as this highlight the challenge in trying to deliver an effective justice system now and into the future when faced with the pressing need to deal with the legacy of our past. That is why we need to get an effective and urgent solution through all-party talks. Chair, I thank you for this opportunity and I'm happy to take the committee's questions.
Okay, Minister, thank you. In terms of the On the Run scheme, can I just, again, for the record, ask you, when did you find out and from whom that such a scheme existed?
As I said in my statement, I was briefed by the Northern Ireland office on Friday the 21st of February after the conclusion of the Downey case, but before it became officially public on the following Tuesday.
Okay. In terms of this being a devolved matter or not, and there seems to be a fair degree of debate around that issue, and do you regard the On the Runs issue as something that is devolved?
I could only regard something as being devolved if it had been formally transferred from the NIO to the DOJ on the point of devolution, and it's absolutely clear that that is not what happened. The NIO continued with the scheme, as the Secretary of State has said now in 2 written statements, following devolution.
Because you said whenever the news was breaking around this scheme, I think it was on the 26th of February, that the issuing of these letters were deeply disturbing, was I think the language that you used in your statement. Why was this information deeply disturbing? Sorry, I found the exact quote, just in fairness to you. Comments made by the Secretary of State in the House of Commons that letters have been issued since the devolution of justice are deeply disturbing. So why did you find it deeply disturbing that these letters had issued, given devolution of policing and justice had taken place?
Well, I think my political opposition to any such scheme was well recorded in terms of some of the comments I've made previously, purely as a party representative. I think the fact that such a scheme was continuing without it being made public, without the scheme being open or being managed in line with the concerns which many of us had expressed, was deeply disturbing.
So it was from a purely political perspective as opposed to a legal perspective that you were deeply disturbed?
I'm not sure it's possible to separate those things entirely, given that part of my political concern, but we are now straying somewhat into my my role as a party leader than anything else. But given that part of my concern was the legal dubiousness, if that's the most appropriate word, of the way in which the scheme was being run. So
it's, for you, there was a merging of 2 issues. There was political and legal in terms of the devolved, the role of the devolved institutions to be dealing with these matters. It was a combination of both.
Well, it was a political concern about the fact that the scheme was set up without being open and transparent and without in any way according to normal legal process, as I saw it.
Because your party colleague in the House of Commons, I think it was last week, 27th of March, said, let me quote Naomi Long, "It's understandable people want to know who knew what and when, what the process was, not least my colleague, the Northern Ireland Justice Minister, particularly given that the scheme continued to operate under devolution, interfering. That is the only word I can suggest with the devolved responsibilities of the Justice Department and other devolved structures of government." And what
I don't think
assessment do you make of Naomi Long's view that this was interfering in responsibilities that had been devolved?
Well, having said it was not devolved, I don't think there's anything inconsistent with saying that a scheme which continued covering matters which should have been regarded as devolved was interfering. I think that's entirely consistent with the point I've outlined.
So, should it have been devolved?
I don't think it should have existed in the first place.
That's not the question, Minister.
No, but it's the answer.
No, but
if you don't believe that a scheme accorded with proper due legal process, then it shouldn't exist either undevolved or devolved.
But again, that's not quite
Well,
the
sorry,
question.
it's the answer.
Well, let me frame it in a slightly different way for you, Minister. However the scheme was devised and one's view of whether the scheme is an appropriate one or not, the scheme was there nevertheless, and it operated under direct rule. As you know, devolution of justice powers commenced in 2010, and the scheme continued to operate. Forget about the rights and wrongs of the scheme. At that point of devolution, should the scheme have been devolved to the Assembly?
I simply do not have the detail as Minister to know whether it should have been devolved or not. I mean, there are issues relating to the justice system which are not devolved and remain undivulged, which will presumably continue to not be divulged if they relate to national security matters, if they relate to issues like admission to separated conditions in the prisons. Those are issues which remain with the NIO. I simply do not have the detail to know, in that sense, as Justice Minister, whether the scheme covers matters which would be properly devolved or not. But what is absolutely clear is the continuance of it is interfering with the normal operation of devolved justice.
Is this scheme...
Sorry, I should say was interfering, given that we are now informed that it ceased in 2012.
Well, has this scheme ceased by way of the NIO, and is it now a matter for your department to deal with?
No requests have been made to my department, and no requests for anything which appears to purport to be this scheme would be accepted by my department. Certainly not as long as I'm Minister.
So is this now a devolved matter?
I really think you need to ask the Secretary of State on that one, since she has said it is and has then apologised for saying that.
Well, let me read what the Secretary of State said on the 27th of March this year in the House of Commons. On behalf of the government, I have expressed regret that we did not discuss the scheme with ministers in the executive. And this is the important point. Especially after we concluded in August 2012 that any new cases should be directed to the devolved authorities. So in August 2012, the Secretary of State, the Westminster Government, concluded that any new requests would now be directed to the devolved authorities. Now that begs the question, is this now a devolved matter? Because the Westminster Government concluded in August 2012 that any more requests would be referred to the devolved authorities.
And there was a degree of confusion about the term which was used in referring to devolved authorities, because in some statements by some ministers of the UK government, the devolved authorities clearly meant the PPS and the PSNI. I think those of us who are members of this Assembly and those of us who work in devolved departments would not accept that that is what the normal assumption is made when reference is made to devolved authorities.
Okay, well, I'm still not clear, given the Secretary of State repeated this phrase, devolved authorities, only last week. And I accept that you got an apology from her when this confusion was first raised. But she's repeated the phrase only last week in the House of Commons, that this was an issue that they concluded upon in August 2012 and rightly apologised to you because they didn't tell you, and I accept that, because they didn't tell the First Minister either. But they concluded then that any more requests would be referred to the devolved authorities. So that takes me into the next area, which obviously, to get clarity around this, legal advice, and you've indicated, is being sought. Could you elaborate on what the issues are that you have sought legal opinion on?
I'm afraid, in line with the usual convention, no, I can't.
Well, have you sought legal advice on whether or not this is an issue that is devolved? And furthermore, should it have been devolved at the point of devolution?
I don't think you heard me, Chair. I said, I'm sorry, in line with the usual convention, I cannot disclose issues relating to legal advice.
Well, with the greatest respect, Minister, this is what you said on the 28th of February, and you said it about Tony Blair. I would think there is a moral onus on Blair to inform the inquiry what was going on, and added, anyone who was a Minister or Prime Minister responsible for the deal must help the inquiry. I would say to you, there's a moral onus on you to tell the people of Northern Ireland, through this committee, what legal advice you're seeking to get to the bottom of a deal that you have said, and I can give you more quotes, has damaged the confidence of the justice system, has traumatised and re-traumatised the victims of those that suffered at the hands of some of these people that have got these letters. So, Minister, tell us, have you sought legal opinion on the basic question of whether or not this is a devolved matter, and should it have been devolved in the interests of those that you say need to be treated sensitively, namely the victims?
I have already explained the convention, Chair.
Well, it certainly is at odds with what you expect of Tony Blair and others whenever you say that they should be cooperating with the inquiries that are going on.
No, Chair, it's not the least bit at odds. What I said was those who are responsible for the administrative scheme have a duty to explain to whatever the appropriate forum is, whether it be Lady Justice Hallett's inquiry or the House of Commons Select Committee inquiry, what they did. That is an entirely different point from me talking to this committee against the normal convention of not disclosing issues relating to legal advice. I'm quite happy to discuss what I have done as Minister, and I come to this committee regularly to make those points. But there are conventions around the issue of legal advice, and I do not intend to break them.
Well, there certainly is a matter of public interest, and I would say to you, Minister, you raised it by saying it was deeply disturbing that these letters had continued to be issued past the point of devolution. So this was an issue that at the time of this controversy you were very keen to highlight as being deeply disturbing. Your party colleague has talked about interference, and now what we're trying to find out is what actions you're taking to get to the bottom of something that the public are saying, who's responsible? Is it the Department of Justice now, because there's devolution of justice, or is it the NIO, and we're trying to get clarity around it? That's why you said in response to me in Assembly question, you have asked for a range of issues you have sought legal opinion upon, but you won't reveal what those issues are. Not even the basic question whether or not this is a devolved matter.
I have made it absolutely clear that there is nothing being done by the Department of Justice, and there will be nothing done by the Department of Justice as long as I am Minister in relation to this scheme. That is the assurance that people need. The precise issue of legal advice I may have sought is a different issue, and I would suggest that the appropriate forum in which issues should be teased out are in the judicial inquiry, the work being done by the Select Committee in the House of Commons, whatever formal inquiry this committee may set up, the other work being done around Ombudsman or Policing Board. All of those are issues which are proper to inquire of people's actions, but not to inquire of legal advice they have received.
Okay, well, I'll park that point. You've indicated that 38 letters were issued at the point of devolution that this current government was responsible for. Have you been able to identify how many were handed out before the current coalition took office?
I have only, when I referred to the 38, and I would refer you to the most recent written statement by the Secretary of State last week, where she increased that from 38 to 45. Statement on the written statement by the Secretary of State on the 26th of March. She referred to the fact that on the 4th of March she had stated 38 in answer to the member for Belfast East, and she had now, after further work, established that there were 45 individuals that had their cases considered, quote, since this government came to power in May 2010.
Okay, so it's at this. So we know what the figure is when they came to power in May 2010. Obviously, the devolution of justice took place a number of months before that point, to which
3 weeks rather than a number of months.
Okay. Well, do we know how many letters were issued by the Labour government in those 3 weeks?
I don't know, and there is no reason why I would know. The information which would be available, and that would be information conveyed by the Northern Ireland Office or by the individuals who were responsible at the time.
And just so I know what actions you've taken during that 3 weeks that you were the Justice Minister, have you asked that information to be released to you?
Sorry?
For the 3 weeks that the Labour government were still in power before the current coalition took office, and we know how many they're responsible for, when devolution of justice
No,
took place?
I have not formally requested. I'm not sure from whom it would be possible to formally request, given the usual conventions about information passing between ministers of different parties in the same department.
Well, I'll get to the convention around papers, because obviously that's an area that we want to get to. I've a whole range of questions that I still want to put to you. Mr. Elliott has asked me to let him in at this point because he needs to leave. So I'll let Mr. Elliott in, and then I'll come back for round two.
Thank you very much, Chair. You're very keen. In that respect, thanks, Minister. A couple of quick points. One's a follow-on to the Chairman's point about the legal opinion. My understanding is if legal opinion is in the wider public interest, there is nothing to stop a Minister from releasing that. Would you agree with that?
That is not the advice I have received, which is that the convention is that legal opinions and the persons from whom legal opinions are sought are not disclosed.
But you do accept that ministers have released legal opinions in the past on the basis that it's in the wider public interest?
That may have been the case, but that is not the normal convention.
But it is an accepted point that can happen or take place?
Well, you'd need to ask those who've chosen to do so.
Okay. So you're saying that there is no convention at all for ministers to release legal opinion?
The only convention I'm aware of is that ministers do not release legal opinions.
Okay. On the point of what the Department of Justice will do now, what actions do you see, or what issues do you see that the Department of Justice need to take in respect of this matter overall?
I think, frankly, the key thing for nearly any of us is to wait and see the outcome of the various inquiries which are underway. Clearly, as you would have seen, the Select Committee started its work yesterday. Lady Justice Hallett has commenced her work. Her report is due at the very latest by the end of June. The Select Committee, I suspect, may take a bit longer, given the breadth of their inquiries. And I think there is little which can be seen which is appropriate for anybody to do until those inquiries are concluded.
Okay, so you don't see that there are any interventions or actions required by the Department of Justice at this stage?
I don't see anything which is appropriate for the department.
Okay. What details of the scheme do you now know? You said you didn't know anything about it at the time. You didn't know anything about it until the information was released. So what do you know now?
I know nothing now which is not in the public domain.
There's no inside information that has been given to you from the NIO other than what's in the public domain?
No.
Have any of the letters been used in the Northern Ireland courts?
Again, I am unaware, but unless it was a case which directly involved the Department of Justice, I wouldn't be aware of information which is supplied in court cases.
But the courts come under the jurisdiction of the Department of Justice.
The management of the courts and tribunal service comes under the Department of Justice. That's different from being aware of the contents of individual cases.
Totally accept that, but because this has come to light, you didn't think it relevant that you would ask the Northern Ireland Court Service if there was any of those letters used in the Northern Ireland courts?
I imagine, had any been used, it's quite likely they'd have been reported in the media. I'm completely unaware, and I'm not sure how that information could have been stored by going back to the old court records. I certainly don't believe it would have been appropriate.
You don't think it would be appropriate for you to check your own court service if any of them had been used?
It would be an issue to be considered in individual court cases where there were prosecutions or whatever. That would be a matter for the PPS, not for the DOJ.
Okay, but surely when the court service comes under the jurisdiction of the Department of Justice, and there has been such a major issue around the letters, it's not appropriate for you to try to establish within your own court service if any had been used within the service?
I suspect the independent judiciary and independent prosecution service would take it fairly ill if I was to start to inquire into those matters. Those are matters for them, not for the administration of the courts.
Well, I would have thought that this is a matter in the public interest. And if in your court service, the Department of Justice court service, if any of the letters were used in any of those courts, that it would have been in your interest to find that out, and certainly in the wider public interest.
But if it was a matter of the public interest, then one would have assumed that journalists reporting court proceedings, which could have happened over many years, I mean, effectively what you'd be suggesting, if it was an appropriate thing to do, would be a manual trawl through thousands of records to see whether anything had come up.
Okay, but anyway, the answer is you didn't look for. Chair, thank you very much. I have to go for a short period, but I'll be back.
Thanks, Elliot. Just to pick up on where Mr. Elliot left off, in respect of arrests, charging, prosecution, do you regard them as devolved matters?
Well, arrests which are the responsibility of the PSNI are clearly devolved matters. Charging, is similarly a devolved matter, but they're not matters for my department. They're matters for independent agencies.
Yeah, and prosecution likewise is a devolved matter. And I accept individual decisions about whether you prosecute or not will be for the PPS, but the overall policy framework in which PPS, PSNI operate is devolved and is something that your department and this assembly is responsible for. So
I don't think my department has any policy responsibilities for the PPS.
we've no role in terms of the types of laws that we would create to determine whether...
The creation of laws clearly is a matter for the legislature, but the policies, other than the law with which the PPS operates, are independent policies for the PPS. And if they apply, for example, the public interest test, that is a matter which is entirely for the director. It's nothing to do with anybody else.
Yeah. But given that we have laws that say it's a criminal offence to go on the run, or if you're on the run, you'll be sought and subsequently prosecuted for it, surely there's a public interest to determine are the PPS and the PSNI actually doing what they're supposed to do, and that's ensure that the law is being followed. Surely it's not enough to say it's entirely independent of me and therefore I'm not even going to ask if this has ever happened in Northern Ireland.
No, but you're now conflating whether there's a legitimate public interest in the way those policies are carried out, which it is, and suggesting it is a responsibility of the Department of Justice, which it isn't.
Okay, well, I think the public will find it hard to distinguish the differences that you're trying to point out as to why we wouldn't be wanting to inquire of the PPS and the PSNI if in Northern Ireland, through the courts, this letter has ever been used or it has ever been presented to the PPS in Northern Ireland as a reason not to prosecute them.
And there are appropriate ways to make those inquiries, but the Minister of Justice asking those questions is not the appropriate way.
But, okay, well, we'll get... Let me stick to where I want to go with this. In terms of your relationship with the Permanent Secretary, Nick Perry, you've indicated that you believe he didn't need to brief you, and even if he did, he shouldn't have because of conventions. Could you point out to me where in the executive guidance that was agreed and referenced at that meeting with the Permanent Secretary that would preclude at any point Nick Perry being able to advise you of the facts around this scheme as opposed to the Minister's views that may have embarrassed them at the time?
Stormont Ministerial Code issued in 2000 made clear that ministers should not seek access to documents created before devolution or created by or for ministers of other political parties, nor should a minister seek to ascertain either from officials or documents the views of previous ministers or advice given to them. Was not in the rather abridged version of the code which was issued in 2008, but is addressed in guidance documents agreed by the Executive in March 2009, which would be the appropriate guidance for executive departments at the point when the DOJ came into existence. Quote, ministers and junior ministers will observe the convention that they and their special advisers should not normally ask to see or be shown documents or papers prepared by NI departments for a direct rule minister or former executive minister of a different party. That's almost a direct parallel to the guidance which applies across the UK government, which is in the Cabinet Office Directory of Guidance, also published in 2000.
I note the operative word there is not normally get this type of
Yes.
information or indeed seek it. But given this was a pretty abnormal, never mind obnoxious scheme, one would have thought it would have been drawn to your attention.
Well, that is your judgment. It is certainly not the judgment which either I or the Permanent Secretary made.
The policy that we have indicates ministers have a legitimate interest in development of policies which they may inherit. On taking up office, officials need to reconcile as best they can the need to provide present ministers with all the information they need to do their job with the convention outlined above, which talks about not embarrassing your previous minister. So,
And it was a policy which I did not inherit on taking up the Department of Justice.
yeah, do you not find it strange that upon the point of devolution, your permanent secretary didn't get his own advice at the time as to whether or not this was a policy that actually should have inherited? I think
No,
you don't.
the decisions on matters being transferred were decisions taken by NIO ministers on the basis of whatever advice they received.
Yeah, and that's what worries me, because the permanent secretary said he made an assumption that direct rule ministers had taken advice. You used the phrase "whatever advice." It's a very haphazard approach to determining what should or should not have been devolved.
No, it was the minister's decision on what was devolved. The issue of exactly what advice they received, is not relevant to the fact it was a ministerial decision.
Did Nick Perry become your permanent secretary and therefore you became his political master, or was he still serving the interests of his previous political masters?
I believe Nick Perry has served my interests as Minister of Justice since he took up his post as Permanent Secretary on the 12th of April 2010.
So you don't feel aggrieved at all that this information, which Nick Perry knew about, he openly now admits that he never told, or he never knew that the scheme had came to an end. But even though the devolved authorities were responsible for continuing with this scheme, he withheld that information from you. You don't have any difficulty with that?
Well, as I heard him say last week, I haven't got the Hansard transcript with me, he said he wasn't aware of whether or not it continued.
Yes, there was a clever play on words. I put it to him, did he know it came to an end? And he said, no, I didn't know it came to an end. But within
Well, I
24
think what
hours
you're
of-
describing as a clever play on words was the Permanent Secretary giving you honest answers.
That'll be for others to judge. He described the relationship he has with you as fine. That was the word he used to describe it, that your relationship is fine. How would you characterise your relationship with Nick Perry?
I think it's a very reasonable adjective. Fine.
Not good? Not bad? It's just fine?
I suspect when he said fine, he wasn't meaning not good. He was meaning fine as in equals good, as in equals professional.
In terms of the issue around this legal advice, and you made reference to it in your opening statement, whenever Nick Perry was in front of the committee, and let me get the exact quote, he tried to explain why you haven't included it. You made reference to it. When I put it to him, did he not find it peculiar that he hadn't been included by you in this? He responded saying, no, I think that under the circumstances it is quite appropriate. Could you elaborate on what you understand that phrase under the circumstances to mean?
Well, I already outlined in my opening statement that I believed it might be perceived that he and I had different interests, and therefore it was appropriate that we should seek separate advice.
You accept, and you have said publicly, and you've said here at the committee, that your permanent secretary has always served your interests. Why would he use the phrase under the circumstances, and why would you continue to say the perceived different interests that there may have been from his perspective as having served in the NIO and from your perspective? If everything's rosy in the garden, why do you need to take the permanent secretary out of the loop when it comes to getting legal advice?
Well, because you've just made the point that because he had a prior role as well.
So you feel that that prior role justified excluding him from your own independent process of getting legal advice?
Well, the suggestion that I've excluded him implies that I went behind his back to exclude him. It didn't. It acknowledged that there were different responsibilities. I don't get all my legal advice by going through the Permanent Secretary. I frequently get legal advice by speaking directly to my legal advisors, because my role and his role are not identical.
But under these circumstances, is that because the public need to be satisfied that there hasn't been something not quite right when it comes to your Permanent Secretary's role, and therefore you'll get this independent legal advice without him being involved? Is it to provide you that assurance that your Permanent Secretary has done his job properly?
Any advice I received was not relating to his role. It was the wider issues relating to the department.
Okay. I'm assuming by that, because a lot of people have made assumptions, so you can correct me if I'm wrong. I'm assuming then that if it's related to whether or not your department should have had this matter devolved, obviously Nick Perry would have had a key role in that at the time, and that's why you haven't included him in this process of seeking legal advice, lest the legal opinion come back and say, yes, this is devolved, it should have been devolved, and thereby your Permanent Secretary didn't do his job.
And you have made a presumption.
Am I wrong in that presumption as to why you've kept him out of the loop getting this legal advice?
You're now taking me into the issue of the legal advice, and I'm not going there.
Okay. In terms of his, the Permanent Secretary, he's indicated that he's met with the head of the Civil Service about it. Have you had a conversation with the head of the Civil Service about your Permanent Secretary in respect of this issue?
Mentioned the on the run, sir. They're all over on the run.
That's the spooks. That's the ones he can't tell us about. My apologies.
Resign.
That's straight from MI5. Sorry, Minister, before you see
Seriously interrupted.
I have not had any formal discussion with the head of the Civil Service about the issue. The issue in general terms has been discussed between him and me whilst we waited for other ministers to turn up at an executive meeting.
So you haven't asked him to do anything formal about this?
I have not asked him to do anything formal.
Okay. In terms of your meeting with the Secretary of State, as she had initially said that this was now a devolved matter, and that obviously caused you some consternation, quite rightly so. You then met her and she retracted her statement and apologised. How much could you tell us about the nature of that conversation that led her to realise that she had got it wrong?
I don't think I need to say anything more than what I've already said about the reference to the devolved authorities. Appears to have been meant by those who drafted her statement as the police and the PPS. But as I said earlier, I think most of us in this building would assume that means the Assembly and the Department, and she made it clear that that was not the intention. Which is why she both apologised then and either the following day or the day after made that apology public.
Have you subsequently sought any of the papers relating to this scheme formally from the NIO?
The only specific issue which I followed up is, as I said, in answer to one of the supplementaries on the urgent oral question you asked me, the issue arose about requests going from the prison service. At the time, the prison service was part of the NIO, but the prison service is now directly responsible to the DOJ. I asked officials in the prison service to follow that up in the specific context that they, at the time, owed their duty to the NIO. Having not had a formal response to the NIO from that, I have written to the Secretary of State formally requesting her if that information can be released to me, given that the prison service is now part of the DOJ.
Okay. In terms of the confidence now in the justice system, and you had indicated back in February that damage has been caused. Who do you feel has damaged the confidence in the justice system? Who's responsible for that damage?
I think the principal responsibility for the damage lies with those who devised the scheme and made the political decision to put it in place, including in particular those who denied that any such scheme existed after the proposed legislation at Westminster was withdrawn.
And in terms of damage, which I assume will concern you greatly, to the PSNI, which in the judgment said they had made a catastrophic mistake, Matt Baggott subsequently apologised and took full responsibility on behalf of the PSNI. How concerned are you about the damage to the PSNI by way of confidence in them from the public?
I think what we see in general terms at the moment is a very high level of confidence in the PSNI as it deals with its responsibilities today. There clearly is an issue of reputational damage from the past. I also note, without having had the detail of studying the Hansard of the Select Committee's inquiry yesterday, that a former senior officer of the PSNI has suggested that the role that was carried out by the PSNI was entirely proper and should not have been apologised for by the Chief Constable. I think there will be details which will emerge as the Select Committee inquiry progresses as to exactly how much responsibility the PSNI had, how much the PPS had, how much may be in the responsibility of other police services across the water, and how much responsibility lay with whoever the officials were who put together the final letters.
And I'm glad you've mentioned the evidence from yesterday's committee hearing. Are you going to take any action as the Justice Minister to get to the bottom of whether or not the PSNI actually was culpable? Because clearly Norman Baxter has defended himself and the work that he was in charge of through Operation Rapid. And I think he said Mr. Baggott had reacted without knowledge, had shown poor leadership, and that he had offered the PSNI up as a sacrifice to cover up for the NIO. How concerned are you about that statement?
I don't think it is my job to intervene between Mr. Baxter and Mr. Baggott. As far as I'm aware, Norman Baxter retired from the PSNI after many years' service prior to the devolution of justice. So the issues which he is describing would have been before any responsibility that the Assembly or I have for policing matters. I think, frankly, that is an issue which will have to be teased out further by the Select Committee.
And indeed, the Chief Constable wasn't the Chief Constable at the time of some of the evidence that Norman Baxter referred to, but nevertheless, he apologised and took full responsibility for the PSNI. So I accept you weren't the Justice Minister at the time, neither was the Chief Constable. But surely you would be concerned about confidence in the police if the Chief Constable has, as Norman Baxter said, reacted without knowledge, shown poor leadership, and offered the PSNI, which you ultimately, as Justice Minister, do have a role as a scapegoat and a sacrificial lamb to cover up for the NIO. Certainly the response I've got from the community and the public from the evidence that Norman Baxter gave yesterday has been damning. What he says is true, and I have no reason to doubt it. And that being the case, will you be seeking a meeting with Matt Baggott to find out if he did offer up the PSNI as a sacrifice to the NIO to cover up what they had been doing with this secret deal?
Well, as I said, there's clearly an issue between what was said by Mr. Baggott and what Mr. Baxter's evidence was yesterday. I think that is something we frankly do have to wait to see the Select Committee, which is hearing that evidence, tease out a bit further. I repeat the point, I think there is a significant difference between the PSNI and the duties it has today and some of the difficult historical issues which the PSNI is forced to deal with in the absence of any other mechanism.
Yeah, well, what I would say, Minister, is that the Garda Commissioner had to resign over secret tapes. Now, who's going to take responsibility within the PSNI for one, contacting Norman Baxter seeking the release of Jerry McHugh, who was subsequently successfully prosecuted and given 20 years, as Norman Baxter believes was seeking to pervert the course of justice, and 2, Matt Baggett, showing poor leadership, a lack of understanding, and offering the PSNI up as a sacrifice to cover up for the NIO. Who's going to take responsibility for covering up for the secret letters when the Gardaí Commissioner had to walk over secret tapes?
Well, I think the answer to that is whoever was responsible will have to account for the secret letters. But I repeat the point, after one day's evidence before the Select Committee, I'm not going to rush to judgment.
Okay, Minister, thank you. Let me bring in some other members. Mr Humphrey.
Thanks, Chair. Thank you, Minister, for being here today. Minister, do you think that the on-the-run scheme and yesterday's revelation in any way played on the decision by the Chief Constable to announce his retirement earlier in the year?
I have absolutely no knowledge whether that is the case or not.
You talk in terms of the damage that this scheme, and I suggest the revelations yesterday at the Northern Ireland Select Committee also have done to the Public Prosecution Service and the police. And I agree with the Chair that I think there's considerable damage done to the reputation of both around this. It shows clearly that politicians should never interfere in policing and the judicial system. Can I ask, what can you do as Minister to rebuild the confidence in the PPS and the police?
Frankly, one of the things I do to restore confidence in the police is resist attempts by politicians in policing decisions.
We're not, with respect, we're not dealing with your actions because you weren't the
Sorry, you
Minister.
asked what I could do to restore confidence.
Yeah.
I can ensure that things are done properly.
I don't really think
today.
that's going to give confidence to the people out there. What are you going to do as the Minister responsible for the Justice Department, ultimately responsible for the police, to ensure that the people out there can have confidence that the police are not politically interfered with? I'm not accusing in any way you of being involved in that, but clearly other politicians have been involved, and we may even wouldn't be aware at this stage of decisions that were taken actually by the police to carry out the political will of some of those politicians.
And I repeat the point that in my time as Minister, some politicians have sought to interfere with policing matters and I have resisted them.
Yeah.
But the key issues when you talk about confidence in the police, there are issues which have to be addressed by a number of agencies, not just by the department. The Policing Board is clearly the key body for holding the accountable. The ongoing role of the Ombudsman is clearly another important issue.
Can I ask you, are you aware of which individuals received these letters, or indeed any individuals who received these letters?
I sort of have made it fairly clear for several weeks that I have no knowledge
Right.
about the detail.
Okay. Are you aware that any organisations, terrorists from other organisations other than the IRA, have received such letters?
I am unaware of any of the detail.
Do you believe that this odious deal between the IRA and the British government has been seen by some as a natural flow from the Belfast Agreement, which your party would have been signatories to?
I actually think if you look at the comparison with the Good Friday Agreement, the Belfast Agreement, if you wish to call it that, where you look at things like the sentences, arrangements, there was clearly a difference between people who still had a conviction on their record but were released on licence. Appreciating that your party didn't approve of the early releases, but nonetheless, for victims, people were released on licence, still holding their conviction. That seems to me to be very different from what happened in this scheme.
Well, given the fact that if we look at the Downey case in particular, the families of the 4 soldiers murdered, I mean, do you believe that those people can, because of the double jeopardy in the application of double jeopardy in the Downey case, do you believe those families will ever see justice for the murder of their loved ones?
But you are now asking me to speculate.
Well,
not anywhere within my realm of responsibility,
okay.
but before my time and in another jurisdiction.
I accept that, but
It would appear on the face of it that after that case was dismissed, unless there are others who may stand trial for those murders, it would appear that those families will not see justice as you describe it.
Yeah. Well, do you not describe it as justice being denied to them? It's not my description.
Sorry, I was quoting your remark back. Yes, and of course I agree with you that justice is seen when those who are guilty of crimes are found guilty in court and pay the penalty.
Can I ask you, do you believe that the letters that Downey and whoever else has received these letters would effectively be worthless without political interference?
Do you mean without prior political interference or without current political interference?
Well, either.
Well, I mean, the answer is I don't know the content of the letters, to know exactly what value they have.
Well,
so I thought you were implying that there was prior political interference which got the letters established in the first place.
yes, and now there should be political interference to ensure that those letters are worthless.
Well, as I say, without knowing the detail of those letters, and I understand what is being reported that there are various different forms of those letters, but without knowing the detail of it, I can't give you an answer on those.
Mm-hmm. Okay, Chair.
Thank you. Mr McGlone?
Yep, thanks very much, Chair, and thank the Minister. Solomon, you've read my comments from the previous day with your Permanent Secretary. And you made reference to, and indeed I made reference to, things that may have been laying about the shelf that could go on to be potentially embarrassing to you because you have inherited a legacy more than anything else. Could you, and you made reference earlier there to your meeting with the Secretary of State. In that meeting, you alluded briefly to it earlier there, but I have to put the same question now. In that meeting, did she make you aware of any schemes about the place, any other schemes which had immunities or implied immunities to British agents, other members of the security force that have been involved in activity, other paramilitaries, or indeed anyone else just laying about the place that could come forward to, well, shed some of the spotlight on you or your department, or indeed officials at your department? Did she make any reference to that? And then likewise, Mr Perry on the previous occasion did suggest that I ask if in fact you were aware of any further scoping exercise that has been done either by your department, officials within your department, or anyone else acting on your department, on your department, or indeed on your behalf, to establish if in fact there were any other loose ends like this lying about the place that would come about to potentially be a source of either political embarrassment or political concern.
Well, I mean, to largely repeat what I said earlier on, the Secretary of State didn't volunteer whether there were any similar schemes. I specifically asked her, was there anything else like this? And she assured me there was nothing else.
Okay.
So I can only go on her word. In terms of any issue of further scoping out, I mean, just to explain a bit more detail, at the time of devolution, there were clearly a large number of files transferred from the NIO to the DOJ. In some cases, files were transferred which shouldn't have been. In others, they weren't transferred, they should have been. And obviously, she relates to things like firearms appeals, where there's a difference between those on grounds of national security, which remain NIO matters, and normal firearms appeals, which are dealt with by the DOJ. And there was a degree of confusion about things like that. So there was some sorting out had to be done. So at that point, after we had a discussion and there was an FOI request as well, and Nick Perry formally instructed the most senior person in the department who hadn't been in the NIO to check whether there were any files relating to on the runs which had transferred to us. And she established that it was the case that there had been, there was nothing transferred on our records. So that was the sole scoping exercise we were in a position to carry out.
And did you ask, or did she make you aware of a scheme implies something which is quite formal and something which has been established either officially, usually officially? Did you ask, or did she make you aware of individual activities or actions which again would apply to British agents, paramilitaries, or members of the security forces who had been involved in criminal activity?
She certainly did not find anything. I mean, the search was not looking for specifically a scheme, but anything relating to on the runs.
She was just, the conversation was specifically about on the runs, was it?
Well, that was the issue of concern. I'm not sure whether it would be possible, given the complexities of the filing system, even though it's supposed to be computerised, it would be possible to search for everything possible without reading every file the department has. But certainly there was nothing apparent which related in any way to this or anything like it.
But you would accept that, again, if anything of that nature which was seen to dilute the fundamental principles of a justice system, and indeed the fundamental need for truth and justice for families people who may have lost loved ones through this, irrespective of whether it's OTR, some other scheme or some other action, that it's imperative that truth and justice and integrity of the political and justice system would seem to be manifest.
Well, I agree with you. It's
Yes.
entirely necessary to get the maximum possible opportunities. So, in a sense, to go back to Mr. Humphrey's point that
Yes.
where it is possible to obtain justice for victims, justice is obtained. And I would say further that maybe on occasions that it may be possible to get people truth, if not justice.
Okay, thanks for that. And Chair, with your indulgence, if I could maybe just ask the Minister for an update on the desert.
I was going to do that,
Great.
Mr. McGlone, once we get through the OTRs.
All right,
So
right, that's okay, that's
we'll
grand.
hold it to there. But we will do that, Minister.
Okay, thank you.
Your indulgence.
I think I said I could take 2 or 3 questions.
You did, yeah. Mr. McCartney.
Thank you very much, Chair, and thank you very much for your patience. In relation to, when you say you first were made aware of this on the 21st of February 2014, was that as Minister of Justice?
Yes.
First time officially you were made aware as Minister?
I presume I was made aware as Minister. A call came from an NIO official after the conclusion of the Downey case, but before it was publicised.
And you, from your own sort of, as leader, political activist, you had no sense that there was a scheme dealing with the on-the-runs as far back as
No.
2000?
I had no sense at all.
At all?
At all.
Right, okay. In relation to the legal opinion, was there a particular reason why you asked for legal opinion?
Well, it clearly is a complex issue which potentially has ramifications for the DOJ.
And have you received it?
I'm sorry, you're now taking me into the issue which I declined to answer the Chair's questions on.
No, I mean, I'm not asking you to tell us what you got or didn't get, but I'm just asking you, have you now been briefed from what you...
I'm sorry, you can smile as you ask the question, but I'm still not going to answer it.
I'm not trying to... I hope the smile wasn't trying to make you answer anything. I just
I
find it
assume
a bit
you'll use
strange.
your friendly character.
I can understand, though, the word convention is fine. You know, convention, when it suits, will be pushed to the side if it's so suited. If it's so suited, any minister, I'm sure, in the morning, they tell us what legal advice the convention would be told. It's not in statute, so therefore there's no legal status. I think it's a reasonable question. If you're seeking legal advice to inform yourself, then I think it's a reasonable question to ask, have you received that opinion? I don't think it's anything to do with convention or content.
I accept you think it's a reasonable question. I see at this point no reason to break the convention.
Yeah, but I mean, if you go into a situation where you ask someone for advice and you come out the other end of it reinforcing your position, I think it would be, without going into what you were told, it would be good to know that. Or no, I was perhaps mildly shocked by the advice I got because I was, as you've said, you knew nothing about this until February the 21st. That no one in the system, even when John Downey was arrested, when it was stated publicly that he was using as part of his abusive process, that he had a letter, no one in the system thought to tell the Minister of Justice. No one picked it up in a daily newspaper report and put it in your desk and said, look, there's something there we should be maybe asking questions about.
Well, the reality is it wasn't picked up as you described in those terms.
And do you think that's a gap, perhaps?
Well, the role of the Department of Justice is not to deal with cases which occur in the jurisdiction of England and Wales.
No, but you have a relationship with the policing board. I'm sure at the end of every policing board meeting, would you receive a briefing or a copy of the minutes of a policing board meeting?
No, I receive a readout from officials who attend the public meetings of the policing board, but I don't receive the policing board minutes.
So in your first day briefing say the 12th of April 2010, which coincided with the briefing of the policing board to say that there was a non-run scheme. None of your officials thought to say, and by the way, the policing board have informed us this week there's a non-run scheme. None of us know nothing about it because we've just transferred over.
I did not receive any briefing on the existence of the scheme.
Do you feel you were badly briefed by your officials at the time? That this was in the public domain of a policing board meeting? You have said there's a read across to inform you what's going on at the policing board, but you weren't informed of this at that time.
I'm not aware that it was at the policing board since devolution took place.
Well, I think it was the board of April when you became minister on the 12th of April, so it was it's pretty close. I think perhaps the date might have been the 7th of April and you took position on the 12th of April, so I'm sure your officials would have been mindful of what the policing board said at that particular meeting. And the minutes wouldn't have been published perhaps for a week or two afterwards. And certainly would have been the minutes of the next meeting in May.
Well, I was not briefed on it.
Would you accept that's a mistake on the part of your officials? I'm sure if there's something comes up in the policing board this month that people would bring to your attention, and I'm sure they bring some things to your attention that are not very, very important, but not to bring this to your attention.
I think the department is busy enough that I only get the important things, but that was not brought to my attention.
And that's not important.
Well, it clearly is considered to be important now. It was not brought to my attention at the time.
In relation to what went previous in terms, is there any legal or any position where if you feel that there's an issue that you're now dealing with, that there are papers in the past you feel you should be reading, have you access to get reading those papers?
If there were issues which related to pre-devolution, in a sense, it's the point which I've just made about the letters requested by the prison service. In those circumstances, I would have to seek the agreement of the Northern Ireland Office to have access to their papers related to pre-devolution, and that's what I've done in that particular case.
And they could give you them?
It is their decision, as I understand it, whether they release them or not.
Has this revelation led you to maybe perhaps consider our issues which we have dealt with as a committee? Perhaps some information wasn't given to you because it was pre-devolution? And one issue in particular was the allegation made that the terms of reference and for the police ombudsman was changed to pre-devolution. And your inquiry by Tony McCusker obviously said that he couldn't delve into those papers because they're pre-devolution. Does that lead you in a position perhaps now you might answer that question? Are there papers saying that there was interference?
But again, what would be my role if there had been interference pre-devolution? I mean, first of all, would be the question as to whether I would have access to those papers. But secondly, what would be my role? My role is to try to get the arrangements right for the Ombudsman at the present time, rather than to delve in what happened under direct rule previously. Well, the correct role for that would be for the Select Committee at Westminster.
Well, the role would be for this Justice Committee to ensure that there was no interference in the appointment of any public office.
I'm not sure.
We were told here it was pre-devolution. It's not something we can inquire into.
Sorry, and that is my understanding that it would have to be referred to.
I know what you're understanding, but you've told us that because of the prison service, that you now have a position that you can go and ask, quite rightly in my opinion, that if the prison service, because this is one of the things that really I find strange in all this, that nobody seemed to know about this, but the prison service seemed to be able to find out about it. Have you asked the prison service how they were informed about the On Their Own scheme?
But the issue for the prison service has to be that even though the prison service is now part of the DOJ, it was then part of the NIO. That's why I have to seek the information as to whether the NIO will release that to me. And I believe I only have that specific interest because the prison service is part of the DOJ. That's different from issues like the Ombudsman, an arm's length body.
Will you be asking the prison service who informed them?
I'm currently asking the Secretary of State to release to me the information that the prison service has, which or had prior to devolution, because of the the issues of ensuring that the prison service runs properly today. That is my role. It's it's a different issue because it's part of the department from another arm's length body.
But at the point of devolution, do you not think that perhaps the prison service could have said, we have been part of the on-the-run scheme, and if we get a request, we might have to...
No, I don't think they could have, because they were at that stage carrying out functions on behalf of the NIO, as indeed they still carry out some functions on behalf of the NIO, which I'm not privy to.
But there'd be a protocol to inform you that they're doing that?
Yes, but I mean this...
I mean, if someone applies, they go into the supervised wings, or if there's a recall of a licence on grounds of British national security, the NIA don't do it in a vacuum. They do inform you of it, I assume.
But the answer to a specific thing like the admission to separated houses is that is done when prison service updates me on the number of people I am managing in the separated conditions. But I have no role in that admission.
No, I know you have
only
no role,
told after people have been admitted.
But you're made aware of it, so there's a protocol.
There's a protocol there, but the protocol in terms of the information you're seeking is the protocol of information passing from one minister to another as departments and parties change.
But the point I'm making is that the prison service were aware of this, so this sort of big claim that nobody knew about it. Someone must have went to prison service and, by the way, there's a scheme here that people can apply, and people obviously went. The prison service must have informed people that it was possible to do it.
But the problem is I don't know what the prison service role was at the time, and I'm still trying to get that information.
And will you inform us of that when you receive it? Where possible, obviously.
I think my role is that I do keep the committee as informed as I can of things which are my responsibility.
Okay.
It may be that the NIO might choose to share information on an entirely confidential basis. So I can't give a guarantee at this point.
And have you been in touch or been appraised of Dominic Grieve, the British Attorney General's view on the status of these letters?
Only insofar as I've read the House of Commons Hansard, when he made a statement.
So that's only information you have.
I've had no direct contact with the Attorney General for England.
And in terms of the role of the Public Prosecution Service, you've sought no meeting with them to satisfy yourself that they've done everything.
No, because I have no role in the governance or oversight of the PPS.
Yeah, but to satisfy yourself, as you go forward, that when people ask you this question, how do you feel about this? Well, you can say, well, I've spoken to a number of people. I'm satisfied that went before I might disagree with, but I'm reassured that A, B, C and D happened.
No, because I have no role in the oversight of the PPS.
Okay.
And this Assembly still hasn't agreed that for the Attorney General even.
Yeah. I haven't read, I think you said earlier on, have you read the Hansard of the Public, the Affairs Committee yesterday, or the NI Affairs?
No, I haven't. I've only seen the media reports and read clips.
I just asked you this question. Would it surprise you that a serving police officer being asked to do something which he considered illegal and unconstitutional and an attempt to prevent the course of justice wouldn't take appropriate action of the person who asked him to do it?
Well, you really are asking me to go on the basis of of media reports as something which happened prior to devolution.
I think it's more than a media report.
Well, if you're asking me, do I expect in 2014 the police officers who are concerned about somebody asking them to pervert the course of justice should do something about it? Yes.
Yeah. Okay, thank you.
Okay, thank you. Mr McGuinness.
Thank you very much, Chair, and thank you, Minister. There is a proposition being put abroad at this moment in time by political commentators and some politicians as well, that, really everybody knew about this scheme, and people knew it for some years, and that even if they didn't know the specifics of it, they should have known that there was a scheme and that the clues were there, and you could have looked at all the clues, joined them up together, and voila, you had the scheme. Now, that's the proposition that's being put about at this moment in time. What's your reaction to that proposition?
I simply don't know whether if somebody had been following up every thread of information that was around, they might have put put everything together and joined up the dots. I certainly did not have the information to enable the dots to be joined up. I mean, for example, I'm informed that there was some information given to the policing board. At the time, I was not on the policing board and had no party colleagues on the policing board. So, I mean, that's the issue where there may have been, smatterings of information here and there, but there was no coherent statement. In fact, the only coherent statement was the Secretary of State when the legislation proposed at Westminster fell, saying there is no scheme. That seemed to me like you're working on the presumption that ministers do not tell lies to the legislature. That seemed a fairly clear-cut statement.
Mm-hmm. And you say that not just as you're here as Minister for Justice, but you also had another hat as leader of the Alliance Party. Had you any indication from government sources
I had,
as the leader of the Alliance Party as well as Minister?
I had no indication whether or not I was wearing any hat at any time.
Yes. So that the administrative scheme that has been outlined, that came to you as a surprise.
Exactly.
There's another proposition put forward by the former Secretary of State, Peter Hain, that although this particular approach in relation to OTRs was not terribly nice or not terribly savoury, nonetheless it was necessary in terms of maintaining the peace process. Have you any observation to make on that?
I think that is the kind of issue which will be well teased out by the House of Commons Select Committee. The same individual almost appears to claim personal responsibility for the peace process when, as far as I'm aware, he wasn't the Secretary of State at the time of the ceasefires, at the time of the Good Friday Agreement, or for some years afterwards.
Thank you very much, Chair.
Mr. Dixon.
Thank you, Chair. Thank you, Minister. The whole sorry tale of where we are in relation to all of this leaves a group of people continuing to be everything from grieved to bewildered to distressed. As Justice Minister, what plans do you have to deal with the legacy of the past, and how do you think we can move towards actually delivering for those who continue to be and will for a long time be bereaved and continue to suffer as a result of the legacy of the past and the damage that the revelations of this and other things that happen do along the way?
Well, I said in my, towards the end of my opening statement that my concern was for the bereaved and for other victims of the past who are left with this dreadful feeling at this stage. For me, it does reinforce the vital need that we do something to join up an approach. I mean, I'm aware of the political differences in this room as around the executive table as to how we deal with the past. But it does seem to me that some of the proposals that were made during the Haas talks, to look to a historical inquiry unit that could actually deal with these things in a more comprehensive and joined up way, might provide a better measure of resolving the difficulties for victims of the past than what we currently have. And I do think there's a real need that we get that joining up done. I mean, whatever else there may be, and there are clearly other issues which those party talks were intended to address, there is a vital need to ensure that we get the best possible mechanisms given the difficulties which have been seen with the historical inquiries team, the legacy work of the Ombudsman, and the difficulties even in terms of the numbers of inquests waiting. There's a real need to provide something better for victims by getting that sort of joined up system.
Okay, thank you. Just to bottom out this legal advice that you won't tell us about, are you able to tell us when you asked for it?
I can't give you a straight answer off the top of my head, but it was at a relatively early stage after issues became public.
Because And we don't know what you've asked about to do with that, and I've made assumptions, but I'm assuming the most basic question of whether or not this is devolved is one of them. But you did say on the 20th of February in a statement, it is not a devolved matter.
I believe a devolved matter, in the sense that we would understand it in the Executive, in the Department of Justice and in the Assembly, is a matter which was transferred on the 12th of April 2010.
Okay. And then you went on to say in that statement, and as long as I am Minister of Justice, there will be no such scheme within the department.
I believe I've said similar words this afternoon at least once.
You have. But if you don't have the powers, it's a very easy statement to say.
Well, my understanding of the operation of the scheme was that letters were passed, at least at the final point, back to the applicants, if that's the right term, by Northern Ireland Office civil servants. What I can say is no civil servant in the DOJ will write any such letter.
But they wouldn't be able to write any such letter if the power doesn't exist. That would be illegal for them to write a letter if it hasn't been transferred.
You appear to have identified both belt and braces, Chair.
Yeah. Yes, I know, but we've kind of danced around the pin of a head on this to try and get to the bottom of whether or not, as Justice Minister, you believe this is part of your justice remit within your control to deal with on the runs. And I'm still not clear, if you're clear, you actually have that power. So, do you have responsibility for dealing with on the runs?
It's unsurprising that you're not clear, given that the Secretary of State has said this is devolved. Well, no, actually it's not. Well, we devolved it in 2012. Well, we didn't tell anybody at the time, and a variety of other confusing bits of information. What is clear to me is that regardless of whether or not there is power, there will be no such scheme whilst I'm Minister of Justice in the devolved sphere.
But see, it's important to establish if the power is with you, because when did that power reside with you? What was the mechanism for that power to reside with you?
Well, I believe it could only have resided with me had it been transferred to me, and it clearly wasn't.
Yeah, but that still doesn't tell me, though, when you say there will be no scheme. Well, again, of course you'll say that if you don't have the power. But if you're needing to say it, I assume you have the power, but you're making it clear there won't be such a scheme under your watch.
I do not believe I have the power. But if I do have the power, I will most certainly not be using it. Does that satisfy you?
Yeah, that's a bit more clear. Do you feel that the Public Prosecution Service and the PSNI, both of which have been devolved, and you rightly point out the PPS sits somewhat as a law unto itself currently, could they be continuing with this scheme without having to report to you as Minister for Justice?
Well, the PPS certainly does not report to me. The PSNI does not report to me on operational issues.
So they could be continuing with this scheme, yes, but we don't know ultimately who signs off on it, because you won't do it as Minister. Theresa Villiers isn't going to do it as Secretary of State, but there seems to be a cosy relationship established with the English Attorney General that had oversight of what the PPS in Northern Ireland was doing. So how can we be sure that this scheme has ended, except for having to take the word of a Secretary of State who never told us about it in the first place?
That's a very good question, but I fear you may need to ask the Secretary of State that.
Yeah. Okay. On that one, Minister, I appreciate you speaking with us about it. Very briefly, if we can just deal with the Desert Creek position. And obviously we've got a very detailed letter from yourself, and thank you for that. And that covers historical issues with my main concern, and I seek your assurances on this, that the programme board, which has been responsible for overseeing it, certainly from those that were there at the last meeting, has changed. And there were none of the officials at our last meeting which were there previously, so it seems you've got a whole new team on the programme board, because Judith Gillespie has now gone. Alistair Finley's now here, but the other officials have also changed from the relevant departments. So what assessment have you made of the current programme board to be able to actually make sure this project is delivered and we've no more failures?
Well, it's not my job to assess the programme board in that sense. I did speak earlier today to Alistair Finlay in terms of catching up with, the first opportunity I'd had to catch up with him since the programme board on Monday, I think it was the 31st. So that he certainly appears to have taken a firm hand in terms of moving forward from the difficult position we're currently in. Ultimately, of course, whatever the programme board decides will have to be signed off by the Minister of Health, Social Services and Public Safety and myself, and then by the Executive. And I think there certainly is reasonably detailed understanding in both departments now of the necessity to get this scheme right and to ensure that we make the plans for the college at Desert Creek succeed.
And in terms of the failure which the programme board has put very clearly at the doorstep of the design team, Perkins and Will, has a decision been taken yet to actually pursue them through the courts for damages?
My understanding is, but it's not our action, so I can't be 100% sure, but my understanding is that a decision has been taken to seek damages. But I say it's my understanding. I can't give an absolute statement on that.
Mr. McGlone.
Yeah, thanks very much indeed. I read your letter, Minister. It's well, it's good to see some sort of strategy emerging. There's been a lot of reaction to this. The Meet the Buyer event that was held in Cookstown raised huge expectations, and then for people to really be dropped in it by this firm, I don't know what sort of cynical exercise they were engaging in at all, but it left, it really damaged the credibility of the project. It damaged the credibility of the standing of all those that were anticipating to see the project through. But with all that negativity, I'm sure you will see the necessity for the project to go ahead and to go ahead as soon as possible. So, can you, as clearly one of the funding departments, can you give us assurances that that commitment, that level of commitment at departmental level, is there to see the project finished and on the site of Desert Creek, please?
But the commitment is certainly there on the part of the Department of Justice. We have been committed to the project on behalf of both the prison service and the police service, an arm's length body which required decent training facilities for many years. Our predecessors were committed for many years, and we have been committed since April 2010. There is a need. Desert Creek has been identified as the appropriate site. Clearly the issue now is to ensure that we get world-class training in a fit-for-purpose facility, which may be slightly less grand than what was originally planned, but will ensure that it represents value for money for the taxpayer in difficult times, at the same time providing value for the three services.
Do you see, or is it the department's view, that this particular scheme here start as soon as possible within this year, this calendar year?
Well, I think we need to be realistic about what the time scale is. I mean, I set out something of the time scale in the letter. I mean, there's a couple of months' work just in looking at what the exact needs are. But we're already at the point that we have effectively the select list of 5 firms or consortia that were through in the first place. It will be the opportunity for each of them to then tender for the reduced contract. I would hope that it would take a shorter than otherwise anticipated time, given that a lot of it will relate to work for which they've already done the pricing.
Could I ask?
And we will move it as fast as we can.
Could I ask why FCC and Gilbert Ash are being allowed, or invited, I should say, to re-tender, given they got it so badly wrong and have essentially they brought us to this mess that we're in at the moment. And some of the crazy stuff that we were hearing about them quoting prices on the 19th of December last, and then coming back within 10 weeks, 9 or 10 weeks, to say that the percentage hike in their prices had gone up 24%, because they said they were testing the suppliers and subcontractors. And at the same time, those suppliers and subcontractors were telling people like myself that they, or the firms acting on their behalf, or sorry, I should say the people acting on their behalf, we're back round the market again, saying to them, we've had your quote, now give us your other quote. A lesser quote, in other words. In other words, they were out there driving the market down and at the same time coming back in and telling the project management board that the prices were up 24%. Now, really, I think the credibility of that consortium in doing what they did and bringing us to the point of dashing people's hopes, and I really don't understand the logic of them being reinvited to do and potentially make a mess of things as they've done before.
Well, I hear what you're saying. I obviously can't comment on the detail of what you're saying local potential suppliers are saying. But I mean, my understanding is because a select list of 5 was established, that select list of 5 remains in play. But clearly there will be issues to ensure that tenders are realistic
And are credible.
Realistic, credible and stuck to.
Yeah, okay. Thanks for that, Minister. Thank you, Chair.
Mr McCartney.
Thank you very much. I was going to ask you to get legal advice on this, but I know even with a smile on my face I wouldn't get anywhere. But
Permanent Secretary did.
as part of this, I mean, the last briefing we got was very comprehensive, and you could, I'm not saying you could predict this, but certainly it was one of the outcomes that was very, very graphically spelled out. But as part of the reappraisal, will the procurement process be examined just to see what mistakes were, if there were mistakes, but how they impacted on the over projection of the budget?
I think the programme board is well underway on that already.
Okay, thank you.
Okay, there's no other questions. So, Minister, can I thank you for coming to the committee? It's much appreciated.
I know.
That's nearly saying. We've all been trying to find when you make it there. That's what it is. They need it.
It's not.
Well, because he can't hold it.
That's nearly it.
Okay, item 5 is a briefing on the results of consultation on an equality impact assessment of youth engagement clinics. So if officials want to step forward. The relevant papers are pages 196 to 512, and let me welcome Moira Campbell, Deputy Director of the Criminal Justice Development Division, Chris Matthews, Criminal Justice Development Division, Mary Augie, Director of Youth Justice Services, Youth Justice Agency, and Acting Inspector Lee Russell from Policing with the Community of the PSNI. You're all very welcome to the meeting, and this will be recorded by Hansard and then published in due course. So, Moira, I'm going to hand over to you, and then members will have some questions.
Okay, thank you very much, Mr. Chairman. We've now briefed the committee on a number of occasions on youth engagement clinics, and today we're focusing on the outcome of our recent consultation on the equality impact assessment of the operation of the clinics and the proposed way forward. The YE clinics and indeed the EQIA itself have been developed and refined through good quality engagement with the youth sector and other key stakeholders at every step of the way. And in the early stages, some of those discussions were at times quite challenging, but I think we've now reached the point where there is a shared view that YE clinics can help us to achieve better outcomes for young people and promote the best interests of the child. The key benefits of the clinic approach that we would see are that it allows young people to make better informed decisions about their options at an earlier stage. It helps them to understand their options and to get the information they need about the consequences of whatever decision they make. And it lets service providers identify where they or their family may need some support. And again, that happens at an earlier stage. Our starting point for this work was, as you'll recall, a desire to prevent cases proceeding to the youth court that didn't need to be there, and we achieved that during the pilot. We also reduced the time taken to deal with these types of cases. The average processing time for clinic cases during the pilot was 39 days, which was 14 days faster than other non-clinic diversionary disposals. And when compared against processing times for court cases, which is where some YE cases would have ended up if it weren't for Clinic, the process is considerably faster. The purpose of this recent consultation was to check that we had correctly analysed the equality impacts of the YE approach, identified the correct mitigations where there were potential adverse impacts, and that we were doing all we could to promote better equality outcomes for young people. Although the number of written responses to the consultation was small, we just had 6 responses, those we did receive were constructive and thoughtful, and in the case of the Children's Law Centre, engaged on the analysis in a considerable amount of detail. I think we could take some confidence from the fact that the issues identified by our consultees mirrored what we had found ourselves in producing the EQIA. Some very helpful suggestions have been made about how our proposed mitigations could be strengthened and our analysis augmented. And these are reflected in the revised draft EQIA, which includes a new section on the outcome of the consultation. Respondents were supportive of the clinics in principle and what they aim to achieve, but some concerns remained around the detail of how they're delivered in practice. We believe, though, that all of these concerns can be addressed, and we've already put the work in train to do this. The key themes in the responses were around access to legal representation, consistency between districts, safeguards for young people, including young people with a disability, putting the best interests of the child at the heart of the process, and the risk of rolling out before we were ready. In response to those, we've proposed the following mitigations, which are listed in the papers in the paper we sent from page 116 of the revised EQIA. Those are, firstly, Measure 1, the ability of a prosecutor to review any decision to refer or not to refer a young person to a clinic. Measure 2, updating the leaflet handed out to young people at the start of the process to make it clear that it's a voluntary process and that they can still opt to go to court. Measure 3, that an assessment should be made of all appropriate adults to ensure that they're capable of acting in the child's best interests. Measure 4 is the inclusion of an explicit requirement to consider the best interests of the child in the entry criteria for the clinics. And Measure 5, which is about taking a series of steps to make it easier for young people to access a solicitor and to proactively encourage them to do so. I think the effect of the consultation has been to enhance one of the proposed mitigations, the Measure 1, the first one I mentioned, and to add the further 2 mitigations, Measures 4 and 5. We would like to thank all of those who responded and for doing so in such a constructive way. In terms of next steps, subject to any views expressed today, we plan to start rolling out the youth engagement model before the summer, and we plan to roll out incrementally so that we can make sure that staff locally are fully trained before they commence running clinics in their area. We'll be reviewing how things are working in practice at each stage so that if any issues arise in a particular location, we can identify those and address them as quickly as possible. And we intend to continue to engage with stakeholders as this project is taken forward, and we will make them aware of any new issues that might be highlighted through ongoing monitoring. And we'd be happy to take any questions on the outcome of the consultation.
Okay, thank you. Mr McCartney.
Thank you very much, and thank you for the briefing. You obviously outlined a number of areas of concern which you've ascertained. Was there a sort of lower than expected pickup on people seeking legal advice?
In terms of the numbers, there were only, I think, 7 clinics where the young person elected to bring a legal representative with them. So I suppose we would have expected maybe it to be a more common practice. Certainly, the young people were all proactively encouraged to consider legal representation. And certainly we didn't want there to be any barrier to that. We made it clear that legal aid would be provided for the provision of legal advice. Really what we've sought to do in the mitigating actions is to make that as clear as we possibly can through updating the guidance. And we'll be reinforcing this in training as well, that we should be taking all steps possible to ensure that they can avail of a legal representative. I think since the pilot phase concluded, there have been another 17 clinics where a legal representative was present, but again, that's a minority of the clinics. I think, though, we would want to stop short of compelling a young person to bring a legal representative. We think that would feel like too much of an escalation in the process. Diversionary disposals are intended to divert young people out of the formal process, so we don't want to make it compulsory. But certainly we're doing all that we can to ensure that the young person is aware that we would like them to bring a legal representative, that funding will be provided for that, and that it won't in any way adversely impact their case if they decide to bring one.
Okay, thank you. I think that's the best approach. In terms of the consistency of approach between the police districts, I mean, I think that's crucial because, I mean, where best practice is there, then that should be the benchmark. You don't want it to become, you get progressive and then somebody not as proactive, and that doesn't become the benchmark. I think where there's best practice and good practice, then that's how the R division should be encouraged to aspire towards. So, I mean, I think that's an excellent approach. Okay.
Mr. McGuinness.
Thank you very much. I really want to explore along the same lines really as Mr. McCarthy in relation to legal representation. I take it even if you wanted to make legal representation compulsory, you couldn't?
I think it would be very difficult to do that.
Was there? Did you probe as to the reasons why there was a lack of legal representation? Was it because the process was regarded as really a non-judicial process? Might that have been the reason?
We did ask about that when we took feedback from the young people themselves and from their parents and carers. I think one thing we uncovered was that there was a fear that if you appeared with a lawyer that it would look as though you were maybe more concerned about what the young person had done, that you thought that you needed that level of assistance. I suppose a lot of parents...
Made it seem more serious, is that?
It would make it feel a bit more serious in terms of what had occurred.
Yes.
Or that you were in seeking some way to adopt an adversarial approach with the agencies concerned.
Yes.
And really what that underscored to us was the need to make sure that people didn't feel that choosing to bring a legal representative would be interpreted in any way by the agencies operating the clinics as some sort of escalation on the part of the young person or the representative, and giving them reassurance around that. Now, I'm hoping that some of the organisations, particularly within the Youth Lobby, who have been very closely engaged with us in this, could potentially be a source of advice and support to young people in making those sorts of decisions as well. They could offer an independent view perhaps on the reasons why having a legal representative there could be beneficial to the young person. It's really about ensuring that they are equipped with all of the information they require to make a well-informed decision. Certainly the staff at the clinic seek to do that, to give as much information as possible to the young person, ensure they have the time to think about their options and consider them, and ensuring that they're properly supported by an appropriate adult as well. But certainly I think we're happy with the principle that we should be doing everything we can to make it as easy as possible for the young person to access the advice.
Yes.
And certainly we haven't seen any reluctance on the part of solicitors to come in and play that role. That was something we were mindful of when we were conducting the clinic. Would legal representatives want to come and undertake that role? We haven't had any indication that is an issue or a problem for us. Is there anything you want to add from the experience of the clinics?
I suppose from an operational point of view, it's not an adversarial atmosphere at all. It's quite a child-friendly atmosphere, and I think parents and children, when they come into that atmosphere, recognise that, and perhaps then that influences their decision as to whether or not they want legal representation there. Because there's always a social worker present from the Youth Justice Agency, we are bringing that welfare approach as well. So it really isn't like a court setting whereby a family or a young person feels that legal representation is necessary.
Just by way of information, the young person, if they admit fault, and I'm putting that in a fairly as neutral a term as possible, if they admit fault, they're still advised to have legal representation.
Yes.
And are they also advised, well, look, you know, at some stage in the future, this could be disclosed to an employer
All of
or
those
some relevant
consequences are fully
authority?
discussed with young people, and their adult, who's usually their parent. So
And their parent or guardian would be aware of
Yes,
that?
very much so.
Yeah. And that's done on a routine basis? Yeah. Okay, thank you very much, Chair.
Okay, thank you.
Can I ask just one small? Is the proceedings recorded?
Not verbatim, no.
No, they're not recorded. Okay.
Okay. Any other members? No? Okay, well then, thank you very much for committee. Thank you. Okay, members, well then, the committee's content that the Department publish the final EQIA and commence rollout of these clinics across the remaining police districts. Yes? Content. Okay. Human trafficking bill. I'll take members through the bill clause by clause. We've had 2 weeks where we've had some discussions in respect of it, and this is the 3rd week where we'll be putting most of the clauses formally, and then on Tuesday we will be putting the remainder of the clauses formally to members. So hopefully the papers have highlighted the ones in advance of this meeting to members that formally we need to agree or disagree, and I'll take you through each clause, and we can have discussions on them.
Chair, what document are we working from?
There is a tabled pack,
Yeah.
which commences from page 13 in your table paper. So
That's the document.
if we go to page 13, that'll give you the clerk's memo, and page 15 then starts where we are on clause 1. Page 15 has clause 2 at the top of it.
Yes.
So that's what I'll be going through.
Yes. Thank you, Chair.
Okay, in terms of clause 1, the definition of human trafficking and slavery offences, committee agreed that they were content with clause 1 as drafted at this stage. However, depending on the results of the Department of Justice consultation on its proposals to simplify and consolidate the legislative framework around human trafficking and slavery offences, some changes may be required. Now they're all going to be very technical in nature, and therefore we had agreed that we were content to go with clause 1. So I was going to formally put clause 1 to members. So is the committee content with clause 1 as drafted? Agreed? Agreed.
Yeah.
Clause 2.
Chair, could I just make a point at the start?
Yeah.
I'm quite happy in principle, because I haven't been here the last 2 weeks. My apologies for that. I had apologies for both.
You're okay.
Quite happy to accept the human trafficking bill as it's going through. However, we reserve our judgment to maybe make amendments, as any party does,
Yes.
at a later stage, or to oppose somewhat. There are a couple of clauses that I have specific issues with, and I have raised some of them here in committee, but that'll be for a later stage. But I'm quite content just at this stage.
Well, Chair, just on a point of order, I mean, when we're expressing our commitment, to these, our content with individual clauses, we're not saying in absolute terms we agree with every dot and comma.
Yeah.
In the clause.
Yeah. No. I think that's standard for committee consideration. From a committee point of view, at this stage of a bill, we have to agree, disagree with each clause, but we can also put commentary around the clause, and then obviously as chair of the committee I can reflect where there has been discussion and where members have got some issues, and it'd be useful obviously if members are, and some have already, indicate where their current thinking is on the clauses, and obviously that'll go into the committee report, but that doesn't preclude obviously parties putting down further amendments, because indeed the department and indeed Lord Morrow haven't been able to provide us with the final amendments to the bill, so they'll have to do it as well. Clause 2 is around the consent irrelevant for victim of human trafficking or slavery offences. The committee agreed that we were content with Clause 2 as amended by Lord Morrow to make it clear that consent is irrelevant. Members also noted that consequential amendment may be needed to this clause if proposed Clause 2.2 of the Modern Slavery Bill is enacted in a similar way in Northern Ireland following the Department of Justice consultation. So the question will be put on clause as amended by Lord Morrow, and the text of the report will reflect the context of the committee's position. So let me put that question. Is the committee content with Lord Morrow's proposed amendment? Agreed. Is the committee content with clause 2 subject to Lord Morrow's proposed amendment? Agreed.
Agreed.
Clause 3 is aggravating factors. The committee has agreed that we're content with Clause 3 as amended by Lord Morrow, the Department of Justice, or as amended by Lord Morrow and the Department of Justice, and noted the Department was still looking at the definition of vulnerable adult. The Department is currently seeking to agree to further amendments with Lord Morrow and has indicated that they should be able to give us this for Tuesday's meeting. So I know members had indicated that we were content with the travel of direction, but for sake of completeness, if we can get the exact wording of the amendments, then I think that's better. So Clause 3 will be formally put on Tuesday's meeting. Clause 4 was minimum sentence for human trafficking and slavery offences. Last week, the committee considered advice provided by the Bill Office on the amendments proposed in relation to 4.2 by Lord Morrow and the Attorney General, which indicated that the amendments have the same objective, which is to avoid a suspended sentence being imposed under Clause 4. In the committee's deliberations, we had erred towards Lord Morrow's amendment, which is what the Bill Office indicated was the most appropriate to use. So Clause 4 will be formally put on Tuesday. I know previously some members had indicated some concern around the general concept of a minimum sentence in legislation. Other members had indicated obviously they don't have a difficulty with that, and some members had indicated that they felt that the exceptionality element to this amendment meant that it wasn't a minimum sentence because there was an exceptional clause to it. So at the moment that's been the general conversation around this particular clause. Happy for some members to comment on it, and then we'll formally deal with it on Tuesday. Mr.
Chair, yeah, obviously, sorry, were you coming to me? Chair?
Yes, I thought you were maybe looking in.
Obviously, the department had raised the issue of the minimal sentence. I'm just wondering, are there ongoing discussions with the department and Lord Morrow on this particular clause? I'm not sure why you highlighted that. Or are those exhausted? And
my understanding is that those are exhausted, and the department will be opposing Clause 4 because of the view around the minimum sentence concept.
I understand why.
Lord Morrow indicated that he had had discussions with the Attorney General, and that the exceptional element meant that it wasn't a blanket minimum sentence, that there were exceptional cases, or there could be exceptionality to it. So therefore, Lord Morrow has put it forward that this isn't a blanket minimum sentence, and that's been the discussion. Mr. McCartney, were you trying to get?
No, I mean, I think you summed it up. I mean, our sort of position would be in and around just the concept of minimum sentences, but we're willing to listen to how people explain out exceptionality, know where the onus lies, and what's the latitude for a presiding judge.
Chair, just to reiterate, I said on previous occasions that I believe that there should be judicial discretion. I think that this narrows the judicial discretion to some extent, but it doesn't exclude it completely with the exceptionality clause.
Okay, so we will put this question formally then on Tuesday, around the clause aspect of it. Clause 5.
Chair, can I ask for
Yes, sorry,
clarification?
Mr.
Just the red, the print in red,
Yes.
and this, what is that actually?
What the subsequent papers highlight to you is where the clause as originally conceived is in black.
Yes.
The amendments are in red. So that
could be the department's amendments, it could be committee amendments, or it could be Lord Morrow's amendments?
no.
Should say on it.
If you look, for example, on clause 3 that we were discussing,
Yeah.
which is on page 23, at the bottom you will have clause 3 aggravating factors. This is immediately after the writing in red,
Yeah.
Lord Morrow's proposed amendment, and that gives you the exact wording, which is then translated above into the bill, and you've got the line going through what was originally there.
Oh, right. Okay.
So that was as best
Chair,
as...
those are the accepted changes, are they?
No.
They're the, as proposed, the current amendments.
Sorry, Chair, I'm following. Thank you. That's clarification.
I was just trying to let you see how the new clause would look.
Would read.
I see. Okay.
Clause 5 was on amendments to the Asylum and Immigration Act. The committee agreed that we were content with Clause 5 as drafted, recognising that subject to the results of the Department of Justice consultation on a proposal for a new consolidated offence of human trafficking, which would result in the repeal of Section 4 of the Asylum Immigration Act 2004, Clause 5 could become redundant. Members also noted that if Clause 5 remains, a number of technical amendments would be necessary. So the committee had previously agreed that we were content with this, and let me put that question formally then. Is the committee content with Clause 5 as drafted? Agreed. Clause 6 was around the paying for sexual services of a person. As agreed at last week's meeting, clarification was sought from Lord Morrow on his thinking in relation to his proposed amendments to change person to prostitute, and whether that remains his position in light of the Attorney-General's letter indicating that in his view using the word prostitute goes further than necessary to limit the scope of Clause 6 and will create a hurdle to prosecution that could be avoided. Clarification was also sought from Lord Morrow on whether he will carry out an equality impact assessment on the bill. We're waiting a formal response from Lord Morrow on that. I've had some informal conversations with him, and he has indicated to me that he's been engaging with the Attorney-General and that he was moving towards leaving it as person, but he still hadn't reached a final view as to that would be the case. But I would hope by Tuesday we will be clear on the person prostitute argument, and the formal question will be put on Clause 6 then on Tuesday. The current position of the parties that certainly I'm aware of is my own party have indicated support for Clause 6. We have raised the issue around the person prostitute, and we're still trying to bottom that issue out. Mr Dixon had indicated that his party hadn't reached a definitive view yet on Clause 6. Mr McGuinness had indicated that his party were content to support Clause 6, and Mr McCartney had indicated that Sinn Féin hadn't yet reached a definitive view on it. So that's my understanding as to where we're at. Is anyone able to elaborate further or wishes to at this point?
Could I just ask you, Chair, BPS gave evidence to the committee. I haven't checked the script of their evidence to the committee, but I thought that they were supportive of the idea of using the term prostitute as opposed to person. I think that was their position.
That was certainly why Lord Morrow then made these amendments.
Yes.
Now, my understanding, having been speaking with Lord Morrow, that was partly proposed to try and deal with the unintended consequences of telephone conversations, webcams, things that weren't designed within the clause but would capture that. The PPS had raised that as a concern.
Yes.
So what Lord Morrow is trying to see if can work is keeping person but amending it, as the Attorney General suggested, in a way that then means it's only focused on what was the real reason behind it, not to capture lap dancing, telephone services and that aspect of it.
Yes.
So hopefully on Tuesday we'll be clear on the person prostitute issue, but we'll have to formally, obviously, consider it on Tuesday.
Chair, just to say that we're reserving our position on clause 6 at the moment as well. But anyway, we'll be taking a definitive decision at some stage in the near future.
Okay. Okay. Well, on Tuesday then we'll take the formal question around it. Clause 7 was requirements and resources for investigation or prosecution. The committee has agreed that it is content with Clause 7 as amended by the Department of Justice to remove 7.1 and cover training in Clause 15, thus omitting then unnecessary words that are in 7.2. So let me put the question. Is the committee content with the Department of Justice's proposed amendments? Agreed. Is the committee content with Clause 7, subject to the Department of Justice's proposed amendments? Agreed. Clause 8 is around the non-prosecution of victims of trafficking in human beings. Clause 8 may not be necessary if assurance is given by the PPS in relation to its prosecutorial guidance, which deals with human trafficking cases, address Lord Morrow's concern in relation to the non-prosecution of victims of trafficking in human beings. Lord Morrow has also indicated that he is awaiting recommendations from the Joint Committee in Westminster, which is currently considering the question of how non-prosecution of victims should be dealt with as part of its scrutiny of the draft Modern Slavery Bill. We agreed to give this further consideration as to whether or not we support the principles underlying Clause 8 as outlined by Lord Morrow in his letter. So my sense of where the committee was going with this was, whilst disagreeing with the clause, the committee was supportive of the principles behind it. So we would formally disagree with the clause but support the principles, and then that would allow us to withhold judgment pending the outcome of the work of the Joint Committee at Westminster. But for the purposes of next Tuesday we would need to agree a position, and that was my sense of where we were going. Any other members?
Chair, I've always had some problems with Clause 8. It's probably exercised my mind more than Clause 6, unlike most others, but I do understand the reasoning behind it, and I understand obviously the sentiments. Again, the principle, obviously I can accept that. Just the specifics of it I don't agree with, but there's probably mechanisms for dealing with that, and ways to deal with it. I've spoken to CARE on the matter as well, obviously who are giving some advice to Lord Morrow in some depth on it, and I know they had indicated that they were hoping, or that they anticipated significant either amendments to it or maybe the removal of it. So, but that's my view.
Yeah.
Chair, I would just say that again I refer to the PPS. And they expressed their concerns about this clause 8, but they did give a reassurance. I thought at the time that given the prosecutorial code that it really would meet the objective, the ostensible objective of Clause 8 as outlined by Lord Morrow. So I think that the necessity of Clause is probably in doubt. And I would think that if Lord Morrow is reassured, then I think that this clause will not go forward.
Okay. Well, we'll prepare the formal question based on that position. That we can formally disagree with the clause, but support the principles behind it, with a further caveat that, you know, doesn't preclude anyone doing something if they don't feel that the other avenues that Lord Morrow is certainly awaiting bear some fruition. So, but for the purposes of next Tuesday, we'll prepare a question on that basis. 9 was victim of trafficking in human beings. The committee has agreed that it is content with clause 9 as amended by Lord Morrow, subject to the Department of Justice's proposed amendments to clarify definitions of victims of human trafficking in relation to the distinct roles and responsibilities of both DOJ and Health in providing support to victims and potential victims of human trafficking. The definitions are connected to the proposed amendments to clause 10. The wording won't be available before the end of the committee stage, but nevertheless the committee was of the view previously that these are technical, and we were content to support clauses that were before us. So unless there's any other comment around it, I'll formally put the question. Is the committee content with Lord Morrow's proposed amendments? Agreed. Is the committee content with clause 9 subject to Lord Morrow's proposed amendments? Agreed. Clause 10 is requirements for assistance and support. The committee has agreed that it is content with clause 10 subject to the Department of Justice and Health proposed amendments, which again sets out their respective functions, responsibilities of each department in relation to the assistance and support to be provided to victims of human trafficking. Officials have indicated that the wording of the amendments will not be available for consideration before the end of the committee stage. This is the same argument that was used in the previous clause, that these were technical, but the committee had agreed that we were content with where we currently were with it. So unless members have any more comment, I'll formally put that question. Is the committee content with clause 10 as drafted? Agreed. 11 is compensation for victims of trafficking. Concern was expressed that the guidance proposed by the Department's amendment to clause 11 may not ensure adequate compensation could be paid to victims of trafficking. The committee agreed that we would give consideration to options available to provide the Assembly with a degree of control in relation to the content of the guidance. The Bill Office had prepared a number of draft amendments which could be found in page 52 of members' tabled pack. This includes a regulation and guidance which would be subject to affirmative or negative resolution procedure, but it was highlighted that this is that it is usual to see regulation making powers or duties to issue guidance in legislation, but not usually together. An alternative option which would not require amendment to the bill would be to seek a commitment from the Minister, either in writing or on the floor of the Assembly, during consideration stage, that the Department will consult the committee on its draft guidance and take full account of its views. We briefly discussed this last week, and I indicated that I wanted to bring it back. I know, Mr McGuinness, you had raised this previously, just before the committee would take a final view on how we would handle it.
Yep. Well, I'm not sure if the technical approach, but it could well be that at the end of the day that the Minister would, on the floor of the Assembly, state that the Department would consult with the committee about the draft guidance, and that might be a better way of doing it. I feel that there's so many obstacles within the scheme, the compensation scheme, that no matter what way you do it, procedurally, that it might be difficult to get the desired result, which is actual compensation for the victims of trafficking. But so long as there's a commitment, I think, on the part of the department to try and resolve this issue, I think we should be content.
Okay, well, certainly I'm content to push the Minister that he will give a commitment on the floor of the Assembly around this issue.
Yeah.
If we take it forward on that basis, then are members content with that approach? Well, I'll put the formal question then on Clause 11 next Tuesday. Clause 12, the committee agreed that we were content with Clause 12 as amended by Lord Morrow. The committee noted the Department of Health has advised that it does not intend to bring forward any amendments to the clause. The Minister for Health has communicated with us, and I haven't had an opportunity to read it, so just give me a minute. Okay, doesn't tell me a lot. The Minister for Health's continuing to liaise with Lord Morrow in respect of this, but there doesn't seem to me any indications that that'll be completed by Tuesday, or by Tuesday. So on that basis then we'll put the formal question today. Is the committee content with Lord Morrow's proposed amendment? Agreed. Is the committee content with Clause 12 subject to Lord Morrow's proposed amendment? Agreed. Obviously if there are technical amendments from the Minister for Health, we'll have to deal with them as they arise, but seeing as they're not here in time, we can't deal with it. Clause 13 is protection of victims in criminal investigations. Committee agreed that we were content with Clause 13 as amended by Lord Morrow and the Department of Justice. Noted the Department may need to bring forward a further technical amendment. The Department has now indicated that it does not plan to bring forward any further amendments. So let me question, is the committee content with Lord Morrow's and the Department of Justice's proposed amendments? Agreed. Is the committee content with Clause 13 subject to Lord Morrow's and the Department of Justice's proposed amendments? Agreed. Clause 14's amendments to the Criminal Evidence Order 1999. Committee agreed that we were content with Clause 14 as amended by Lord Morrow, and notes that the results of the Department of Justice consultation may have a bearing on this clause. So on this, members, have any further comment, then we had agreed with it to put the question today. Is the committee content with Lord Morrow's proposed amendment? Agreed. Committee content with Clause 14 subject to Lord Morrow's proposed amendment? Agreed. Okay, Clause 15 on prevention. Committee has agreed that it is content with Clause 15 subject to the final wording of the Department's proposed amendment. The Department had provided an indicative draft of the wording of the amended clause. The Department is currently seeking to agree the final wording with Lord Morrow and Legislative Council, and they have indicated that they should have this with us for Tuesday's meeting. So I know we're agreeing with Clause 15, but for the sake of completeness, if we have the exact wording, that would be more beneficial. So hopefully that'll be there for Tuesday, and then we'll put that clause formally. Clause 16 was on the Northern Ireland Rapporteur. Committee noted that the remit of the Anti-Slavery Commissioner, which would be created by the draft Modern Slavery Bill, could be extended in Ireland. Members agreed to consider whether they wish to indicate that they support Clause 16, but also wish to consider the position further when there is clarity on the position regarding Anti-Slavery Commissioner, or alternatively they do not support Clause 16 at this time. But we could consider the matter further when there's clarity on the position regarding the Anti-Slavery Commissioner. The discussion around this was either we can, some of us may be content to agree the inclusion of this, but if the Anti-Slavery Commissioner is going to do this work, then it would be likely that we wouldn't see the need for duplication. So I know some members had indicated they supported Northern Ireland Rapporteur being created. I know Lord Morrow's indicated that he wanted to see what the Anti-Slavery Commissioner's role would be, and I think he's currently in discussions with those that are responsible for that to see if it's going to happen. But we need to decide for Tuesday as to how we deal with it. So I know from my own party's perspective we would be agreeing to the clause but saying that it's subject to what happened with the Anti-Slavery Commissioner's position. That we would withhold then a definitive position if that was to develop. So I don't know if any other members want to. Members can comment then. There'll be a question put agreeing to it with the commentary around it that members' views are subject to how this Anti-Slavery Commissioner role is handled. Okay. 17 is on general interpretation. We agreed that we're content with clause 17 as amended by the Department of Justice. So let me put that question. Is the committee content with the Department of Justice's proposed amendment? Agreed. Is the committee content with clause 17, subject to the Department of Justice's proposed amendments? Agreed. 18 is around orders. We had agreed that we're content with clause 18 as amended by Lord Morrow. We noted that the Department was working on minor technical amendments which it hoped to forward to the committee before the end of committee stage. The Department has now indicated that the further amendments are subject to clause 16 falling from the bill, and as the position will not be settled before end of committee stage, wording of any necessary amendments are not available. So I'll put the question formally again. Is the committee content with Lord Morrow's proposed amendment? Agreed. Is the committee content with clause 18 subject to Lord Morrow's proposed amendment? Agreed. Short title and commencement. In clause 19, we considered the wording of draft amendments that were prepared by the Bill Office make provision for the bill to commence in royal assent, or alternatively commence the bill a short time after royal assent, to build in some flexibility for those departments and other organisations who will be involved in the implementation of the bill. Members had indicated a preference to set a time frame for commencement of the bill. We agreed to give some further consideration as to whether that should be 2 months or 3 months. I'm content to go with 3 months if members are content. That's the exact wording of the amendment. If members are content, that we will put that question formally on Tuesday. Okay, that concludes that element of the bill. The remaining clauses will be put formally on Tuesday. So thank you for your forbearance. Back to the 7th, the Attorney General for Northern Ireland's draft human rights guidance. The AG is required under Section 8 of the Justice Act 2008 to issue guidance to named criminal justice organisations on the exercise of their functions in a manner consistent with international human rights standards. In January this year, the committee considered, we agreed that we're content with the draft guidance for the prison service around conditions of imprisonment. The Attorney General has now provided the draft guidance he has prepared for the prison service in relation to prison order and discipline, which is for consideration by the committee. So if members have any further comments on the draft guidance, if not, then the Attorney General can bring them forward. Okay. Item 8, draft public guidance on use of reasonable force to protect against crime. Members will be aware of some of the issues around this and the exchange we've had with the Agriculture Committee. The Department has responded indicating that crime prevention advice has been developed by the PSNI's local crime prevention officers, who are in daily contact with farmers and the Department's Rural Crime Unit Steering Group, and that includes representatives from the Department of Agriculture, Rural Development and National Farmers Union Mutual. They too have had sight of the crime material. The information provided by the PPS is a factual report of the factors that may be taken into consideration by the courts in deciding whether reasonable force has been used. Therefore, consultation on this aspect wasn't appropriate. So subject to the committee's final views, the Minister intends to invite the PPS and the police to publish the guidance as soon as practicable. So if members are content with the guidance as drafted, then we can note it and forward this to the Committee for Agriculture and Rural Development for their information. Agreed?
Chair, didn't give a time scale, did it? Don't see any.
Just as soon as possible, we're saying.
Just we know how some things can be. So, go off the radar.
Very cynical.
Okay.
Well, certainly it's an item that we can come back to if members feel that it's being unduly delayed. Correspondence. There's a number of items of correspondence. I'll draw attention to a number of them. Item 1 at page 55 in the meeting folders, in response from the Department of Justice on the report on Rapid Assessment Treatment Service for Drug and Alcohol Misusers, a 10-year review, 03 to 13. At our meeting on the 6th of February this year, the committee considered correspondence from His Honour Judge David Smith providing the report, and agreed to send a copy of the report to the Minister of Justice and the Probation Service for comments on the benefits of the programme and the position regarding funding it and other parts of Northern Ireland. The Minister has indicated that the Department has not provided any funding for the programme, but following an invite from the Director of Addiction NI, he is due to visit their offices and learn more about the programme and their work. So if members are content, we will request a further response from the Minister following his visit. There's a response then, item 3, from the Department to the Committee for Finance and Personnel, Inquiry into Flexible Working in the Public Sector in Northern Ireland, and if members are content, we will forward a copy of the response to the Committee for Finance and Personnel. Then there's a response from the Department on issues in the Northern Ireland Audit Office report on sickness absence in the public sector relevant to the Department of Justice. The Department states in its letter that it continues to take proactive approach to management of sick absence. The biggest contribution to absence levels was made by prison grade staff, which is not unexpected given the frontline nature of the job. The Department also refers to information it provided on the 3rd of March regarding the analysis of sickness absence in the Department for 2012-13. So members are asked to note the position and actions. Then on the tabled pack, there's correspondence from the RUC George Cross Widows Association regarding the withdrawal of funding for the association by the Department of Justice. If members are content, we will write to the Department requesting the background to and rationale for the decision that has been taken to withdraw this funding, and what consideration has been given to identifying alternative sources of funding for the organisation, given the small amount required at £38,000 per annum. Mr. Humphrey?
Yeah, I agree entirely, Chair. And given the evidence given by the Minister earlier on to this committee, it's not consistent with what the Minister said in terms of treatment should be afforded to victims, and these widows are very much, those affected directly by this, are very much the sort of victims that we should be supporting.
Well, I'm happy to pursue this.
Chair, just in relation to this, I'm surprised at the way this group's been treated, particularly because it's a very small amount. But was there not a commitment under the Patten proposals that, or Patten recommendations, that in fact that this group be supported? I'm not sure if that was the position or not. I'm really seeking clarification. If it is, I mean, it seems to me to be a commitment arising out of the Patten report.
I don't know, and I don't know enough probably around why this money has been withdrawn. So I think I would like to ask the Department for the background to all of this.
Yes.
I know it's certainly caused a degree of angst for those involved as to why this has happened, considering the small amount of money as well that it is. So there's some sensitivity around the issue. So I'm certainly happy that we would raise this with the Department, get a response, and then see where we can take it from there. The other tabled correspondence that we received yesterday was a letter from Byron McGrory. Obviously, he was one of the individuals that the committee had invited to come to give evidence around the On the Run scheme. he had provided a holding response initially, and now he has provided a definitive response where he's indicated that he'll not be appearing before the committee because he doesn't believe that it was ever a transferred matter. So I'm certainly not content to leave that response there. I've spoken to colleagues that sit on the Northern Ireland Select Affairs Committee, and I know Barra will be asked to appear before that committee, both in the role that he played as a solicitor that got these letters for the individuals concerned, or at least some of them, but secondly, in respect of what role he may or may not have had as director of the PPS. So I appreciate that that committee will be cross-examining Barra around these issues, but nevertheless, to refuse to come to this committee I think is unhelpful, and I would like to get legal advice from the Assembly as to where this committee stands by way of how we can pursue this request, and if we can. So if members are content, I would like the Assembly's legal people to look at that response from Barra and advise the committee if we do have the power to ask him to come before the committee around this particular issue.
Chair, I would be of the view that with regard to Mr McCrory's previous history as a solicitor in private practice and advising clients and so forth in relation to on-the-run issues, I would have thought that that is a privileged relationship. I do not think that he could be compelled if he was a witness to this committee. I don't think he could be compelled to disclose anything surrounding that, given the legal privilege that attaches to that client-solicitor relationship, and therefore I think he would be precluded from giving evidence in relation to that aspect of this matter. And in relation to his current position as director, it may well be that because this matter A was not devolved, and B that preceded his appointment, that may have very little to contribute and may well not be compellable anyway, but that's a legal matter that we'll clarify with the Assembly legal team.
I know the area that when the committee discussed the initial invite was how he had handled this scheme as director of the PPS, not as a solicitor, and that'll be for the Select Affairs Committee if they want to probe that area. I think we have been primarily looking at post-2010 devolution of this scheme, or not, as some may indicate, and that was the context of the invite for Barra.
Right.
And what arrangements he put in place to deal with the conflict, which he has admitted that he had, and therefore he didn't have a role, but that was why he was initially invited. And I would want to bottom out with our legal people the grounds that we have or may not have to continue to invite him. I know that our advice has always been we can invite whomever we wish, but they can say no. It's whenever we want to exercise our Section 44 powers of compellability then, and that's where I would like some advice from the legal team.
Mr Chairman, I noticed at the bottom of Mr McCrory's letter he says an independent, fair and effective prosecution service. You may recall several months ago we raised this issue about the failure to deal, in our opinion, effectively with the Liam Adams case, and my memory at the time was that the Attorney General agreed to carry out an issue report as to whether the DPP had handled that correctly. And we're now, I think, about 5 months later, and there doesn't seem to be any indication of that report being forthcoming. Could I suggest that we as a committee write and ask for a copy of that document?
Yeah, I can remember the case. my recollection of this issue at the time was the controversy was, why was Jerry Adams not prosecuted for failing to report the abuse that he was aware of? And someone dispute that. But I remember the director of the PPP invited the Attorney General to review how the PPS had handled it at the time. The indications were that would be completed within weeks, and I'm not aware of that having been the case. So certainly if members are content, we'll write to the Attorney General for that report, and we'll write to the PPS for that report as well. Agreed. Then if no other comments on correspondence, we'll agree to action it.
Yes.
Chairman's business.
Sorry, I thought you meant on that correspondence. Just in relation to the Randox
yes,
situation and the Northern Ireland Prison Service contract, are we to take it that simply the contract with the Scottish firm still stands, and that there will be no variation? I wasn't quite sure from the correspondence. I didn't read it in any great detail. I'm sorry, I apologise. Maybe we could come back to this on another occasion.
Yeah. Christine is advising me that the Department of Finance may have responded, but the Department of Justice hasn't responded yet.
Yes. Well, perhaps we could look at it again, because it is getting late and so forth, and it does seem to me to be a little bit more complex than on the face of it. Because my understanding is that Randox really analyses pharmaceutical drugs and has an expertise in that, whereas the Scottish firm specialised really in prohibited drugs, as opposed to prescribed drugs. I think that was the material difference between the two firms.
Yeah.
And of course, the problem in our prisons relates more to prescribed drugs than it is to prohibited drugs.
Well, I'm happy that we can look into it further. We can chase up with the department for their response, and then we can look at it.
Thank you very much, Chair.
Chairman's business. There's a letter from the All-Party Group on Country Sports requesting a meeting with the committee. Correspondence came from Danny Canahan, who is chair of that All-Party Group, requesting a meeting with the committee to discuss security specification for firearms dealers and other issues. So, if members are content, we will set up an informal meeting between this committee and the All-Party Group. I know a number of members already have a feel for what the issues are, so for those members of this committee that could meet with them, that could be helpful. And then I know that All-Party Group will then want this committee to try and pursue some of those issues. But
Chair, I don't know if I need to, but declare an interest in being a member of that All-Party Group.
So am I. So I'll meet with myself. Item 2 is a meeting with the prison service that I had on chaplaincy arrangements that was raised last week. The Deputy Chair and I met with Brian McCaughey and Mark Goodfellow from the prison service headquarters. On Tuesday of this week, we discussed the proposed changes to prison chaplaincy arrangements. Now, while changes are currently being discussed, no final decisions have yet been taken, but the service has to be delivered, they said to us, within the existing budget if they can secure that. Brian McCaughey is due to meet again with church representatives early next week for further discussions on how chaplaincy services in prison should be delivered, and has given a commitment that he'll provide then a written update following the meeting with those church representatives. Is there any other business? If not, then we'll be meeting on Tuesday in room 29 at 1 p.m. To go through the final elements of the human trafficking bill, and lunch will be provided for members.
This is the Northern Ireland Assembly